Hi, everyone, and welcome back to another episode of our podcast here for the Intellectual Property, Media, and Entertainment Law Journal at Fordham University School of Law. Today, I'm joined with Yafit Lev-Aretz, who is an assistant professor of law at the Zicklin School of Business at Bruch College at the City University of New York, and she's also the director of tech ethics at the program for the Zicklin Center for Corporate Integrity. Thank you so much for joining us today.
Hi, thanks for having me.
So, just to go over, this is such a big and convoluted topic. So let's try to narrow down the industry a little bit at first. How might you go about classifying one of those home sharing websites like Airbnb or Vrbo? For example, in 2019, the European Court of Justice ruled that one of those websites would be more of an information society service rather than a real estate website. And then, as we're going to be talking about a little bit later, the courts in Airbnb versus City of Boston, and Airbnb is always involved in a lot of these lawsuits, defined it as an online marketplace. So how would you go about defining one of those websites?
So it is clearly not a traditional real estate service. Information society sounds right, but also feels kind of overbroad. It is also true that both Airbnb and Vrbo operate as online marketplaces for both short-term and long-term housing accommodations, practically facilitating hotelization and long-term leasing of excess capacities in both personal and business-owned properties. I believe that it's the combination of kind of granular options, long, short-term, room, house, urban, rural, and the ability to capitalize on excess capacity that made those services so attractive to both hosts and guests. The terminology implemented by this industry is that of hotels or vacation rentals, but with a personalized touch.
Right. So does this classification, would you say, change the ways in which lawmakers and courts both would seek to regulate them and create new policies around them?
Oh, absolutely. Absolutely. Classifications and choice of terminology matter. Facebook, for example, for years tried to claim that it's just a technology company. Similar claims were made by several sharing economy platforms, including Airbnb itself. And by characterizing Airbnb and Vrbo as information society services, the court distances these services from any real estate and hospitalization regulatory obligations, which is exactly what you want when you are a startup attempting to disrupt a years-long traditional industry.
Definitely. And different states have different laws, and even different cities have different regulations, specifically targeting home sharing websites in this big tech world. So what problems could also arise if this website is classified differently in, let's say, California versus Massachusetts?
So different classifications result in regulatory harmonization issues, just like in any other space, right? Regulators must balance protection of property rights with mitigating externalities created by those rental accommodations and borne by the local community. Variations in balancing choices mean that in different states, we're going to see different benefits to either property owners versus the local communities. Obviously, different regulations also result in forum shopping, but it's important to note that when Airbnb itself is involved in the litigation as a party, arbitration and choice of law are mandated in its terms of service, which minimizes forum shopping to some extent.
That's a really interesting point that I didn't even think about, was that forum shopping when you're considering where that you might litigate down the road, which of course every big company is thinking about, and how might users be affected in that. And like you talked about a little bit, there are those big tech companies, and then these websites are more in the hotel. So there's a weird balance there. When Airbnb went public, its share was at $68 per share on the first day, and then jumped within a day to over $114. That put the company's valuation at over $86 million, far surpassing other popular hotel chains such as Marriott or Hilton, who were both valued at $42 billion and $29 billion, respectively. So why might Airbnb's platform itself stand out to consumers over the traditional hotel model?
Well, before I answer that, let's first not forget that it took the company quite some time to get there. You know, in the 2017 law review article by Brian Kalo and Alex Rosenblatt, it's titled "The Taking Economy, Uber Information and Power." They note that there are very little studies. In fact, they found only 6 relevant studies on the effect that Airbnb had back then on the hotel industry. So we're talking just 5 years ago. And when you search for such studies today, you find numerous studies, like quite a lot. So yes, the company is doing very well, but it wasn't an overnight success. So I just want to remind all of us of that.
Right. That's a great point.
In terms of why Airbnb has been more appealing to consumers than traditional hotels, I see a few main drivers behind Airbnb's success. One is that Airbnb did much of what Web 2.0 did to internet users. It gave users tools that were traditionally used by professionals only. When I say gave them tools, I mean both the access and especially financial and technological access to the tools, but also simplification of tools that traditionally required professional knowledge and a lot of experience to master. I mean, if you think about it, 30 years ago, only media professionals could shoot a video, edit it, and then have it shared with potentially billions of people. YouTube gave everyone the power to do it at almost zero cost. And TikTok these days, right, took those video editing tools and made them even more mainstream and accessible to all, including young audience. The same process took place with Airbnb, if you think about it, right? Anyone can now turn their house, apartment, or even bedroom into a hotel. I think that also for many users, Airbnb turned their residential excess capacity into money. Now, this term, excess capacity, I borrow from Robin Chase. She's Zipcar co-founder. Mm-hmm. And I think the idea that you can use your unused space to make money is something that is appealing to many, many people. This paradigm is essential in the sharing economy and seems to be one of the main reasons for Airbnb's appeal. Airbnb also did an excellent job emphasizing the personal aspect of the experience, right? Guests enjoyed meeting their hosts, learning about their way of living, and being exposed to differences. Of course, the personal experience is also the source of many concerns and abuses, but Airbnb has not emphasized the potential downside. Another reason, which is kind of dovetailing the one I just mentioned, is that Airbnb made almost any place on earth accessible with hosts, even in rural areas where you couldn't book hotels. Now, it's true that vacation rentals of this sort are not new, but going back to the access element, if you lived in a rural area, it would have taken you a lot, both financially and in terms of labor, to turn into a vacation rental with proper exposure. Now, all it takes is an Airbnb account and some good photos.
Definitely. It's so interesting how fast it's developed. And I know when I'm looking to travel anywhere, I usually go to Airbnb first because we also have that notion that it's cheaper and less expensive than one of those big hotel chains. But as it's been expanding so largely and is everywhere, are there any problems that could arise if one company in specific, such as Airbnb, has control over this entire sector of the travel industry?
It's funny that you asked this question because the Senate Judiciary Committee is meeting today to discuss 2 bills that are intended to rein in the power of big tech. And the problems that could arise in the home sharing contexts are no different, right? Concentration, unfair practices, anti-competitive environment that discourages new players from entering this space. These are all the same issues across the board, and Airbnb and this industry is no different.
That's great. So there are so many different issues, but I'd really like to focus on some issues that you are an expert in. And so let's talk about privacy. What are some examples of privacy concerns that exist in the traditional hotel industry? And how might those differ from an online home sharing website?
So in the traditional hotel industry, hosting was centralized, but information collection was more decentralized. Interestingly, home sharing websites decentralized hosting, right? It's no longer hotel chains or professionals only. It's really everyone, or at least this is how it started, but centralized information collection, because now instead of having, some hotel chains collecting information about their guests, now we have 1 or 2, home sharing websites collecting massive troves of data about both guests and hosts. There are, of course, privacy concerns as to how much is collected, how this information is used, who is it shared with, and more. There are also concerns about sharing information with law enforcement or city officials, which are not new and definitely existed when hotels were dominating the space, but they are different today. Information is required today for a longer list of causes: tax evasion, safety, violating city regulations, etc. And another privacy concern has to do with cross-platform sharing of personal information. For example, in December, Airbnb and Vrbo announced a pilot program to actively share information about party houses. They wanted to address chronic offenders. Both rental platforms already have programs in place to identify listings that caused community concerns, meaning that there is already some sort of internal ranking system and enforcement mechanism, but now they join forces to have this information shared for more effective detection of violations. Now, this program is generally a good thing, of course, but we already know the risk of this kind of profiling and problems such as biases and selective enforcement that it can result, right? Not to mention concerns of discrimination that these platforms have had for years now, to the point that now in Oregon, as of January 31st, hosts will only be able to see guests' initials instead of their first name until the booking confirmed.
Oh, wow.
Yes, and this is again because of concerns around discrimination. There are also privacy concerns in the more individual level that we haven't seen coming up in the traditional hotel industry. For example, the use of surveillance cameras in rental properties. There is currently a very lively debate as to whether it is legitimate to use surveillance cameras as a host, how much, where, and if at all. With hotels, these questions have been more clear-cut as norms have already been established. So when you go to a hotel, you kind of expect to be surveilled when you're in public areas. You don't expect to be surveilled, obviously, in your hotel room, but you will not be surveilled in your hotel room. So norms are already established, but when it comes to private houses, people are like, no, we need to have this safety mechanism. So you have a very lively discussion at the moment, a lot of threads on Reddit and elsewhere about what should be the norm around surveillance in Airbnb homes.
That's all insanely interesting. I mean, there's so many different routes to take and so many things that come up constantly. And I think also, just to everybody listening, we always have to remember that when talking about privacy, we're always talking about that reasonable expectation that anybody has when going into one of these websites or even with a camera or in your own home. And there are all these types of security strategies that companies use to protect the privacy rights of users and hosts. But when a guest is renting a property, what kinds of security strategies should companies like Airbnb be pursuing to protect that privacy in that situation?
So I think everything we just mentioned about collaborating with other platforms to flag up serial violators, I think direct communication with local regulators is also very important. And we saw some of it happening in New York City. There was a lot of litigation before that, but at some point, I think both parties realized that it's obviously better to just work together and find a mutual way to address these concerns. And working through the community guidelines to really guide the community, right? Draw lines where lines are needed and effectively enforce them.
Would you say that transparency is an important part of these policies?
Yes, absolutely. Transparency, specifically in privacy policies, is extremely important. But before I explain why, I just want to emphasize that I strongly agree with criticism of the use of privacy policies to govern all aspects of handling personal information. Privacy policies have been rightly criticized for being overly long, barely readable to anyone without legal education. And I'm just going to give you a secret here that even if you have legal education, you're not guaranteed to understand them, right? And they are also very vague to the point that they don't really offer you a clear picture of the anticipated information flow. Now, I agree with these concerns. I will also add to them that there are some aspects that privacy policies simply should not govern. When we share genetic information, for example, we don't share information about ourselves. We share information about anyone who is related to us genetically. Is it reasonable to give us the power to share information about other people who did not agree to the sharing just because we clicked, I agree? When we agree to political targeting of ads or to targeting of ads generally, we allow instances like the Cambridge Analytica scandal and the more recent Facebook files and broader social and the targeting, of teenage girls with harmful content to take place. These decisions have consequences, and specifically social consequences, that are by far broader than what we should leave to individual choice. And we already know that it's not even a real choice through privacy policies. With that said, transparency in privacy policies is not only important, it is crucial. It's true that most of us never read them, but these policies are read by professionals and the media who occasionally flag up problems and concerns. And these policies also give us an understanding of the industry standard. They allow companies who opt to be more privacy protective, they give them an opportunity to stand out. So I have my criticism of privacy policies and the way they are used, but at the same time, yes, they are super important, and the transparency they offer is very valuable.
So going beyond transparency, would you say that you believe that these policies are doing enough to protect the platform users and their rights when using one of these websites?
The answer is no, because again, for the reasons I just mentioned, they don't do enough because these policies are just about informing you, and people do have the choice of not clicking I agree, but then they cannot use the service.
Right.
So, you're left with a set of terms that you either agree to or you cannot use the service. And most of the time you will agree to the terms, even if those terms don't do enough to protect you. And most of the time they will not do enough to protect you because of the problems we mentioned before around privacy policies. There are all kinds of interests that are not always aligned with your interests as a user when information sharing is being agreed upon in privacy policies.
Right. When you're using one of these websites, you're not exactly bargaining with the company about what information you can and can't share, or if you want to stop sharing your information, you usually have to delete your profile, or even at times email the company to let them know that you want your information taken off. There's not a lot of clear-cut ways for users to, like I said, bargain with these companies about these policies and how that is being enforced or used. These companies also care a lot about regulation, and a lot of times they go through litigation to be able to muster out these problems in court, and so that there's a clear-cut answer. We talked a little bit about the Airbnb versus Boston. Airbnb was in a long legal battle with New York, which actually they settled in the summer of 2020. And now that's a whole other issue, is getting that law up and running. But the court in Airbnb versus Boston touched on concerns from the city regarding illegal short-term hosts. In June 2018, the city enacted an ordinance limiting the types of properties eligible for use of short-term rentals, restricted how many days per year a property may be used in that manner, and required registration of units that are to be used for that purpose. In addition, they did define penalties for those units. The data provision required monthly disclosure of 3 categories of information for Airbnb in Boston's listings: the location, whether the listing was a room or a whole unit, and the number of nights that the room or unit was occupied during that preceding month. At the end, the court easily concluded that Airbnb would be irreparably harmed by having to comply with an unconstitutional requirement that would disclose its private business information. And the court found that this was easily concluded based on that 3rd category, the number of nights that the unit was occupied. stating that, Airbnb does not publish this information on their website. So there's no reasonable expectation of privacy in that regards. So that there is a reasonable expectation of privacy in that regards. Like I mentioned earlier, every time we're talking about privacy, this reasonable expectation is really, really important to discuss. So how does the reasonable expectation of privacy standard account for an average user on Airbnb or another website like this?
Wow, this is an excellent question. We use the reasonable expectations of privacy test all the time since CATS in 1967, right? But there is a very basic question here as to what's reasonable. And what's reasonable is subject to social norms that are constantly changing. If someone would have told you 40 years ago that someone will be listening in on all of your conversations inside your house, you would have never believed that. But, then came Alexa. So
right.
I think whether this application of the reasonable expectations of privacy standard actually reflects what a typical Airbnb user would deem a reasonable expectation of privacy is a question I'm obviously not equipped to answer. I assume the answer would change based on not just the time of the question, but also the location of the user, right? What's reasonable in terms of data sharing in Belgium might be different than what's reasonable in the eyes of a New Yorker. So, but this question I think is super interesting and super important because it highlights the importance of context. And this is a good place to mention my favorite way of thinking about these questions, which is Helen Nissenbaum's contextual integrity theory. This theory provides tools to thinking about situations just like this one and helping in classifying an information flow as legitimate or illegitimate. And I'm happy to discuss more about the theory if you're interested.
Oh, please, definitely.
Okay, so the idea in the contextual integrity theory is again to think about an information flow, and you refer to different parameters like the actors who is sending the information, who is receiving the information. You're thinking about the context. Are we moving from one context to another? For example, a conversation you had with your doctor in a medical context. When you move this information into a commercial context because your doctor sold this information to a commercial entity for profit, that would be inappropriate. But not just because the context changed. There are a lot of considerations that we take into account in the question of what is a legitimate information flow. Mm-hmm. And the reason I love this theory so much is because it's very, very sensitive to social norms and to their changes over time. So an information flow that is deemed illegitimate in a specific point in time might be deemed legitimate later on. And, to me, one example is always the Google Glass. So if you remember, actually Snapchat came up with a similar product.
Right. The glasses, right? Where you could go and take pictures of everything you were seeing.
And everybody were freaking out. Everybody were like, no, we're not using that. And Snap got a lot of bad press because of this product. 2 years later, Google comes out with it and Twitter is exploding because everybody wants to get the invite to get the glasses. So I think this is a really good example for how social norms change over time. And like the Alexa example I gave you, people get used to the idea of sharing information in a certain way, in a certain context. Mm-hmm. For example, when social networks started, people didn't think it was reasonable to take information from your social network in questions such as admission to college.
Yeah.
Whereas today it's obvious, right? Everybody knows that when, the admission officer is going to come through your social network and just going to look you up online and see what you've been up to, right? So I think when you ask this question about what reasonable expectations of privacy mean, and it's interesting because this whole discussion kind of happens outside Fourth Amendment literature, but there is a lot to the notion of changing social norms that play into this notion of what is reasonable to expect and not.
Right. I think especially in this context, it is important because it is so adjacent. And now we're talking about home sharing. And the Fourth Amendment has always been used to protect the home, to make sure that when you are sitting inside your house, you are the most private that you can be. And now people are sharing their homes on these websites to invite people to come and stay with them for however many number of nights. So as it's been evolving and changing, these concerns in this context has changed over time, especially within the Fourth Amendment issue.
Yeah, agreed. Exactly. And I think this kind of sensitivity to context and to the norms that are changing over time is something that we're not quite there in fleshing out and developing in legal theory terms.
Right. That was a really great point. And thank you so much for sharing that theory. I did write it down so that I can go back and look more into it later, because it was really interesting. So going back to this original case, the Airbnb versus Boston that we were talking about, with this reasonable expectation of privacy, and something that you were talking about also earlier, which is when companies are developing these privacy policies and they've started to share them with third parties and the information with third parties. So even if information is published on the website, like the number of nights that a unit was occupied, might a user still expect to have that information protected from disclosure to third parties? Is that why the court might have found that conclusion so easily from this one factor? Or how would that work?
Yeah, I think you're right. I think the court also made this distinction based on the logic of the third party doctrine,
Right.
under which information shared voluntarily with third parties is not subject to Fourth Amendment protection, in the sense that no search warrant is needed to access that information. But not only the Supreme Court in Carpenter limited the scope of the third party doctrine, but this treatment of privacy is so 2005. Privacy is not about secrecy. I think this is one paradigm we really should move away from. Privacy is not about secrecy. So it doesn't mean that if you shared it with one party, it's now open to everybody because it's no longer a secret. Privacy is not about secrecy. Privacy is about context. Some information is reasonable to be shared in certain contexts and not reasonable to be shared in other contexts. And I think this is what the court might be missing in this respect.
That was really important. I think that your earlier hypothetical about what you say to your doctor is a really good example of the context issue, and what you would want to say in public, and maybe what you're saying to a friend also you don't expect to be shared. And just to wrap all of this up, because this conversation has been so interesting, and I again thank you so much for being on our podcast today, I just want to talk more about anticipation. So the sharing economy is constantly growing, expanding, and responding to new regulations, as well as legal precedents, different contexts that are arising. What other challenges or concerns do you anticipate in the context of websites like Airbnb and Vrbo and HomeAway, and how should these be addressed in the future?
So the home sharing business model is based on strangers trusting each other, right? Mm-hmm. And we have about 2 million people staying on an Airbnb on any given night. Even now during the pandemic, the numbers are really impressively high. And while most stays do not result any safety incidents, I think Airbnb is talking about less than 0.1%. Sometimes strangers shouldn't be trusted, just like your parents told you when you were a kid, right? Mm-hmm. Cases of kidnapping or hostage cases, rapes, even murders had been reported in relation with Airbnb hosting. So one area that I would watch closely is Airbnb's black box unit. Bloomberg reported about 7 months ago, and this is a story I have been very curious about, that Airbnb developed a team of 100 specialized agents, most of which come from military or trauma background, to handle those extreme cases of user harm. There was an Australian woman who was raped while staying in an Airbnb in New York. apparently the keys were duplicated from previous guests or otherwise were obtained through the bodega where they were left for pickup. And the company sent someone from that special unit to handle the case, to kind of clean up, pay the victim to move to a hotel, pay to bring her mom from Australia to stay with her. They also verified that Airbnb was not mentioned in the criminal case, and paid the woman $7 million to sign an NDA under which she will not disclose Airbnb's. I mean, here I'm of course speculating based on that story from Bloomberg that she will not disclose the the connection to Airbnb, the fact that Airbnb maybe should have had some kind of policy about, around how you give people keys, how you get them back, how you make sure they're not duplicated, and so forth. So this is, of course, legitimate business behavior, but when adding to that the fact that users are bound by an arbitration clause in Airbnb's terms of service, we might see a lot of transparency around those issues that should be brought to public attention, going away through arbitration and non-disclosure payments and payouts. So I think this is a very interesting area to watch in the coming years, because we might see that there are a lot of even safety issues that we should know about that we don't get information about because of this kind of bypassing the legal system through arbitration and NDAs and so forth. I think it's fascinating to watch and see what's going to happen in this space.
That is really interesting. Well, thank you so much again. Do you have any lasting thoughts that you'd like to say before we close out this episode?
No, all good. You guys are doing an excellent job in this podcast, and thanks for having me again.
Thank you so much.